Good afternoon. This is Ingrid Culp with Fredrikson and Byron. I am one of the employment lawyers in our employment and labor law group. I am here today with my colleague, Ashley Thronson, and we are excited to be providing this webinar today. Thank you very much for joining us. A couple housekeeping matters. If you have questions during the webinar today, please hover over the bottom of your screen to see the chat feature and enter your question there, and it will be printed out for us during our presentation. We will most likely hold questions for the end of our presentation, and our hope will be to get to all of the questions. If we don't get to your question for some reason, either Ashley or I will be in touch with you later today or tomorrow to make sure that all the questions are answered. We also will reference during our presentation a few template documents that I believe have been provided to all participants. If for some reason you don't have them, let us know. But we have provided a template offer letter, a sample new hire checklist, and one other document with some helpful information for making sure that you're established correctly as employer ready to employ employees. Let's see, I think we will get started. So I'm going to take the first couple topics of our presentation, and then Ashley is going to take the last couple topics. Ashley, I should have said, is also one of our employment lawyers in our group, and we're both very happy to be presenting on this topic. So let's dig in. So the legal landscape, when we talk about hiring, there are so many laws that come into play for good or for bad, and this is really what keeps us employment lawyers and you HR professionals on your toes and having to keep track of a lot of different laws. I'm not going to go into these in a ton of detail now, but more than anything, just to lay the groundwork for all the different things we need to be thinking about. So first, of course, there are federal laws that apply to all of us in the United States, regardless of what state we happen to be employing individuals in. We have our anti-discrimination laws, including Title VII, the Americans with Disabilities Act, the Age Discrimination in Employment Act, GINA, which is a Genetic Information Law, the PDA, which is a Pregnancy Discrimination Act. All of these laws apply to the hiring process because, of course, they protect not only employees against unlawful discrimination, but also applicants. The Fair Credit Reporting Act is a federal law that applies to employers who choose to do background checks as a condition to employment or during employment whenever they decide to use a third party to run their background checks for them. And in my experience, almost all employers, if not all employers that I've worked with, do use a third-party outside vendor for their background checks. So when it's the case, we have to be aware of the Fair Credit Reporting Act and the obligations that apply there. We, of course, have our wage and hour laws, including the Fair Labor Standards Act and the Equal Pay Act, that require that we set our compensation for our existing employees and incoming employees in accordance with the law. We have the Affordable Care Act that applies to certain employers with regard to offering health insurance, ERISA, IRS regulations with regard to wage reporting and taxation on wages, our immigration laws that require us to establish that all new hires are legally authorized to work in the United States. Then on the state and local level, we have our own host of anti-discrimination laws, many of which mirror our federal laws, but there are some unique elements under state law as well. Here in Minnesota, we have the Minnesota Human Rights Act, of course. We also locally have a city-based law in Minneapolis and St. Paul and a few other local municipalities as well. We have our own wage and hour laws, again, that largely mirror the federal law, but not exactly. In Minnesota, we have the Drug and Alcohol Testing in the Workplace Act, which we'll talk about in a little bit more detail. But in Minnesota, if a Minnesota employer is going to require drug or alcohol testing of an applicant or an employee, that is highly regulated by this Minnesota statute and requires a bunch of different steps for compliance. We also have our own Fair Credit Reporting Act with regard to background checks. We've got state workers' compensation laws. We have our own state tax reporting and withholding laws. We have state unemployment insurance laws. Many states, including Minnesota, have a ban the box law that prohibits us from asking about criminal backgrounds on an employment application itself. And then, of course, common law principles. So non-competes, restrictive covenants, how and when and under what circumstances can we get those and get those in a manner in which they'll be enforceable. Promissory estoppel is a fancy term for not making a promise that the employer won't be able to keep. And misrepresentation, of course, is akin to fraud or making comments that are or statements that are fraudulent. So hopefully that overview of the landscape of the laws that we have to deal with when we are considering our approach to hiring employees is enough to get all of our attention to know that there's a lot at play and a lot at stake and a lot that we all need to be mindful of to make sure that we do this in a legally compliant way. So today we are going to go over 5 steps of the hiring process with you. First, we're going to talk about step 1, laying the groundwork before you even hire any employees. And I know and trust that many of you are fully functioning employers, are ready as you exist today, and hopefully have all of this in place, but just wanted to do a refresher to make sure nothing has been missed in this regard. Step 2, with regard to hiring for a specific position, determine the need. We have found that giving some good thought and attention to what you actually need with regard to a new position and a new hire before you even start the hiring process results in typically the best hire and the most efficient process. So you don't get somebody in the door and then figure out that you actually needed a different skill base. Step 3, finding the best candidate. Step 4, making an offer. And step 5, new hire onboarding. So that's the general layout of what we're going to do today. So let's dive in with step 1, laying the groundwork. Before hiring any employees, just a couple things to make sure that you at your company have in place, because these are all legally required. So first of all, you need to register with state agencies. You need to register to do business in the state. So this is typically governed by state law, and in almost every state, if not every state, there's a law that says if you're going to do business in our state, you have to register to do business in our state. You also need to register for federal and state tax ID numbers with the IRS or with your local taxing authorities. You also, in Minnesota and many other states, need to register with the state to have an unemployment compensation account with the state. In Minnesota, our unemployment compensation system is managed by the state, and we pay a tax into the system from our employees' wages. And so every employer in Minnesota has to have registered with the Unemployment Compensation Department so that they know that you exist, and there's a system in place to ensure that taxes are paid into the system from your employees' wages. Next, obtain workers' compensation insurance. In Minnesota and in many other states, workers' compensation insurance is, of course, legally required, but it is obtained by Minnesota employers on the private market. So all Minnesota employers have to go out on the private market and purchase workers' compensation insurance that would be applicable to all of their employees. And as you look at this screen, if you have failed to do any of these steps, it can result in pretty significant issues and penalties and fines if any of these have been skipped. So moving on, before hiring any employees, of course you want to set up your pay and benefit systems so that you have those in place and are ready to go as soon as you have that first new employee. So establish payroll processing, including required withholdings. Some employers, do this on an in-house basis. In my experience, most employers will hire a payroll processing firm to do this for them. But having a good plan in place for payroll processing, who's going to do it for you, and do they know what they're doing, and do they know how to do it correctly so that all appropriate deductions and withholdings are both taken from wages and then remitted to the appropriate federal, local, and state agencies is, of course, really important. If your company is subject to the Affordable Care Act, of course, having a plan in place to make sure that you are complying with the Affordable Care Act regarding provision of health insurance to your employees. And then consider, outside of the legally required benefits, what other benefits might you offer to your employees? Will you offer things like short-term disability benefits or long-term disability benefits or a 401k plan or other fairly standard employee benefits? And if so, be sure to have, of course, the plans established so that you have everything up and running when you have those employees come in the door. We also recommend considering what your policies are going to be and getting those in good shape so that, again, when you have a new employee come in the door, you can simply hand those to your employee. Two key elements, I think, to deciding what your new hire practices are going to be is, does your company require background checks as a condition to employment? Outside of a few regulated industries, background checks are not required by law. It is up to each individual employer whether they are going to require background checks as a condition to employment. I work with several clients who don't require background checks. I work with several clients who do require background checks across the board for all new hires, regardless of position. And then I work with some clients who've decided that they are going to require background checks only for certain positions. And that is legally permissible to require background checks only for certain positions, so long as all new hires in that class of positions are subject to a background check. So by that I mean, let's say that at your company you've decided that you're going to require background checks for all individuals at a manager level position and above. If that's the case, then anybody hired into a manager position level or above must be subject to the background check. You cannot decide on a case-by-case basis that you want to have Dan undergo a background check, but not Susie. It has to be a consistent application within the class of positions that you have decided you're going to require background checks to. I think a good question to ask yourself as you're considering what your company's policy on background checks is the following. What do you want to know at the time of hire? And is there anything that you would rather know at the time of hire than weeks or months or years after an employee has started? If you would be disappointed to learn that a new hire or somebody who's been with you for a while has a criminal background and you would have preferred not to have hired them in the first place if you had known that, then I think your company is probably a good candidate for running background checks. So that's just something to think through on a company-by-company basis. Likewise, drug and alcohol testing. What is your company's approach or policy with regard to drug and alcohol testing? Is it going to be a condition to employment at your company? Again, it is totally up to each company whether they require drug or alcohol testing as a condition to employment. As I mentioned before, in Minnesota, drug and alcohol testing, including at the pre-hire stage or as a condition to employment stage, is highly regulated by our Minnesota statute. So if you have decided that you are going to do background checks or drug or alcohol testing as a condition to employment, we want to make sure that you have everything in place that is required. And we would recommend that you reach out to us or your legal counsel to make sure that you have the appropriate policies, because policies are required, the appropriate consent and authorization documents, and the like. Some other possible conditions to employment that, again, are not required, but you may choose to use at your company. Will you require a pre-employment physical? And if so, to which positions will that apply? Who will conduct your physical for you? And how will you ensure that you are only considering medical issues that have some sort of job relatedness to the position for which the individual is being hired? What will your application process be? Will you use an application, a standard template document that all applicants are required to complete? Again, not a legal requirement, but a fairly common practice. And I would suggest to you a best practice. I really like the use of employment applications company-wide, kind of top to bottom. I think employment applications can capture a lot of important information that you may not capture from a resume or a cover letter or other screening tool. So I'm a fan of employment applications. Employment applications, of course, need to be legally compliant themselves. In Minnesota, they cannot ask about criminal background. There should not be any request for date of birth or other information that will readily indicate an applicant's age or race or other protected class status type data. Let's see, and then create an employee handbook. Of course, having an employee handbook is a best practice with those key policies like anti-discrimination and anti-harassment, so might as well have a good one in place as you pursue your hiring activities. Again, before hiring any employees, engage your outside vendors so you're not scrambling when it comes time to hire somebody. If you're going to do background checks, select your background check agency. And make sure they're a reputable agency who understands the laws that apply to background checks and knows what those laws are and what their role is in complying with those laws. If you're going to require drug or alcohol testing, select your approved testing laboratory. Minnesota does require that only certain approved laboratories conduct drug and alcohol testing, so you'll want to make sure that whoever you select can certify to you that they are a approved testing laboratory under the Minnesota law. Again, if you're going to do pre-employment physicals, select your provider and make sure that they are reputable and know what they're doing. Okay, so you've laid the foundation, you've got good processes and procedures in place for hiring employees. Now it's time to actually hire an employee because you've decided at your company that there is a need for a new hire. So what are some of the steps to put in place to make sure that you really understand what the need is and what you're hiring for before you actually go to market by posting the position? So create the position. What is the title? What are the job duties? Is it full-time? Is it part-time? Is it temporary? What are the necessary skills, experience, or qualifications? What is this position's FLSA classification going to be? Is it an exempt position or a non-exempt position? And of course, we could spend many additional hours together talking about exempt and non-exempt and what is required for exempt and non-exempt status. So if you have any questions on that, feel free to reach out to us separately. But that is important for every position to be qualified as exempt or non-exempt in a legally compliant manner. Where will this work be performed? Does it have to be performed at the company's offices, or might it be a home-based job or a remote position? What's the reporting structure going to be? To whom is this individual in this position going to report? And then, while they're certainly not legally required, it's oftentimes a best practice to have job descriptions. And in the job description, include the essential functions of the position. Let me pause for a moment and talk about job descriptions. And as I mentioned, there's no legal requirement that a company have job descriptions for its different positions, but they can be really helpful, a really helpful communication tool, not only to your new hire to explain what the job is going to be, but just for internal purposes, so everybody kind of understands what the company's structure and organization is and who's responsible for what. That being said, job descriptions can either be really helpful or they can be harmful to a company. And when I have found them to be harmful is in the following circumstances. Either if they're incomplete or there hasn't been a lot of time or attention or thought put into them, or if they've been allowed to become outdated, they just sit on a shelf and many years have passed and they haven't been reviewed or updated. Or if they're used in kind of a spotty manner. You might have a job description here or there, but not in any real across the board procedure. So if your company is going to use job descriptions, I think it's important to view the preparation and the maintenance of job descriptions as an important job, an important task in and of itself, and really understand what your internal processes and procedures are for making sure that they're both well done and kept up to date. A few risky areas when it comes to determining the need and what the specific position is going to be that we wanted to highlight. So, is this service provider that you're going to engage going to be an independent contractor or an employee? Again, this is a topic that we could have an entire another hour or two together on, whether somebody has to be classified as an employee or whether it would be legally permissible for them to be an independent contractor. This is controlled by law. Unfortunately, the employer and the individual don't get to decide in what their wishes are because federal and state law can come in and say, nope, you got it wrong. I will leave you with this on this topic. When in doubt, employee treatment and employee classification is always safest. Nobody's going to come in and tell you that you did something illegal because you decided to treat somebody as an employee. The issue and the risk arises when you have a service provider providing service to your company and you've decided to treat them as an independent contractor. If you are going to use an independent contractor, I would recommend that you kind of fully understand and appreciate the multiple factors that go into that analysis and consult with legal counsel whenever in doubt. Again, exempt versus non-exempt, there's a whole federal and state laws that govern who qualifies for exempt status and who doesn't. When in doubt, non-exempt status is the safest. Nobody is going to tell your company you did something wrong by classifying somebody as non-exempt, so long as you understand and then appreciate that they are an hourly employee and have to record all hours worked and be paid accordingly, including overtime if applicable. The risk comes in when you classify an employee as exempt, and the law would say they don't actually qualify for exempt status. And then, of course, discrimination based on protected class status. All hiring needs to be done without regard to protected class status, and no suggestion that hiring has been influenced by things like age, race, disability, pregnancy, gender, and the like. Before hiring for a specific position, a few other things to keep in mind and to think through thoroughly before you go out to market with your position. What are the compensation and benefits for this position? What is the salary? Or what is the hourly rate of pay going to be, and how does that fit within your compensation system? And is it fair compensation and equitable compensation vis-a-vis the other employees at your company? And again, determine what conditions to employment for this position. If you're a company that applies your conditions to employment company-wide, that's going to be fairly easy. If you're a company, though, that has decided you only have certain conditions to employment for certain positions, then you'll want to know whether this falls into one of those categories. Again, is this a position that requires a background check, a drug or alcohol test, a pre-employment physical? And then one conditions to employment we haven't talked about yet, and again, some companies use these, some don't. Some use them across the board, company-wide. Others use them only for certain positions within a company, are restrictive covenants. Do you require your new hires to agree to certain non-compete or non-solicitation or confidentiality or intellectual property agreements as a condition to becoming an employee with your company. If so, you're going to want to, 1, know that, 2, have well drafted documents that are legally compliant, and 3, be prepared to include those with any offer of employment. Okay, I'm going to turn it over to Ashley, who is going to pick up at step 3.
Okay, so now that you have taken the time and effort to make sure that you are prepared to do business in Minnesota and that you've assessed the need and what exactly you're looking for, now it's time to find who is the best person to fill that need. And so step 1 under this next step in the process would be to prepare the job posting. And just like having all of the time and effort in determining the need, same goes for in preparing the job posting. It will pay off dividends in the long run if you really take an intentional and thoughtful approach to this, because a good job posting will include all of the primary job duties, the qualifications, as well as an equal employment opportunity statement. And this will really help set the expectations of the position, both to make sure that you're getting the candidates' applications that you are looking for, as well as to set the expectations of people who are looking for a job. So hopefully to weed out those that aren't qualified or who may not possess the qualities or the interests that you're looking for. And so being fully informed and setting these expectations really helps on both sides of the equation. It also helps eliminate surprises as you get into the process and are devoting more time and energy, and avoids liability down the road for promises. Ingrid mentioned promissory estoppel as a possible claim, and that could be an issue that can be avoided by having a very clear job posting that lists, all of the conditions and qualifications necessary. And so along this line of being fully informed, you should include in all of the application materials any expectations, including whether you're requiring a background check, a drug test, a pre-employment physical. All of those things helps inform potential applicants that these will be required. I know we received a question asking whether a background check, whether you can indicate in an ad whether a background check is necessary. And so here we're saying yes, it would definitely be a best practice to include that in there to inform everyone. So then step 2 would be to actually post the job. This too requires some intentional thought to make sure that you're posting it in a variety of places so as to avoid excluding particular groups of individuals. So for instance, there have been some recent lawsuits about claiming age discrimination for companies that only advertise on social media. Things like that. Similarly, if you're only advertising online, you want to make sure that it's accessible to individuals with disabilities. So if there's an individual who is blind, that they're able to access the content and be able to apply if they are interested. And so by posting in a variety of places, you hopefully cover the spectrum and include individuals in different groups if they're interested in applying to your job position. So another consideration when you're thinking about posting and advertising the job is whether you should use a headhunter or a search firm. And if you're considering this, or if you do this, just be aware that there is some potential liability for the search firm's methods and communications. There could be joint liability between the two. Similarly, if you are an affirmative action employer, you probably know that there are special procedures and requirements under the law related to your outreach and recruitment efforts. So if you are an affirmative action employer, do make sure that you are following those regulations as well. So then step 3 under finding the best candidate is to determine who to interview. So you collect all of the application materials and determine how many individuals you're going to select for interviewing, as well as who will be interviewed. And along this process, you'll also decide and determine who will not be interviewed, and also make arrangements for those who will be interviewed. Along those same lines, you'll probably sense a theme. It's all about preparation and being very thoughtful and intentional in your approach. And so this carries through to preparing for the interviews too. We really recommend that you prepare standard interview questions and make the process as consistent, as standard, and prepared as possible. So make sure that you pick who will be doing the interviews, training them to know exactly what to say and what not to say, and having these standard interview questions will help with that. This helps control the process, makes it consistent that not only you're getting all the information that you need, but also that you're not getting the information that you don't need. Interviews are mines for potential liability. There's all kinds of stray comments, whether unintentional or well-meaning, that could really help set the employer up for trouble. For example, any sort of comments about someone's kids. You might think that that's just simple small talk, but an individual who's being interviewed might interpret that as discrimination based on marital status or sex or any number of things. And so having these standard interview questions and training really helps to avoid these pitfalls. And then the next thing is to make sure that when you are interviewing these individuals, that you're being cognizant of any accommodations that are necessary, both in the application and interview process. It would be good to ask sort of in a general manner of, are you able to conduct the interview with or without reasonable accommodation? Or, let them know that reasonable accommodations are available so that they can complete the interview and application process. And along these same lines, sticking to the prepared questions and being aware of the stray remarks really helps avoid liability down the road. And this goes for even your notes. So you may be inclined to, during the interview, to take notes on candidates to help keep them straight and determine who ultimately is the best candidate. Just be mindful that that is documentation and that you should avoid writing down any sort of notes that are related to protected characteristics, age, race, gender, anything of that nature. Really, even if you're using it just as a point of reference, is not a good thing to be writing down, because if that candidate ultimately isn't selected and sues the company for discrimination, that obviously would be evidence that that particular characteristic was a consideration. Along those same lines of what you should be asking in interviews, make sure that you are asking individuals about restrictive covenants with current or former employers. This is a big thing, especially if these restrictive covenants such as non-competes or non-solicitation agreements are common in your particular industry. There is a claim under the law for what's called tortious interference with contract. And basically this claim is that this applicant's current employer, if there is a non-compete that is valid, the employer could sue your company for interfering with that non-compete if you end up hiring that individual. And the standard under the law is whether you knew or had reason to know about whether there was this non-compete. And so you really do need to ask the candidate and ask whether there is a non-compete in place, ask to see any agreements that the candidate has with a current or former employer, because you really do need to do your due diligence to see if there are contracts out there that would prohibit this particular individual from working with your client, and you need to know that up front. So then step 4 would be to continue the interviews, and along with the application process, the same thing goes in the interview process, that you want to set the reasonable expectations, both of the process and of the position. It helps keep both sides informed and knowledgeable as to what to expect, as well as whether they're interested in the ultimate position. Be wary of making promises about the job. This goes back to the promissory estoppel issue. And so I had a case where an individual thought that they were offered the job. They didn't have any sort of qualifications, weren't as explicit in the interview process and in the written materials. And so ultimately that employer got sued because the employee or the candidate wasn't fully aware of the expectations, and there was this miscommunication that ultimately they thought they were hired and they weren't. So it really is important to be very clear in the communications with these applicants and to set up those reasonable expectations. And then the final step of this process would then be to select the most qualified candidate based only on the legitimate business interests, and to make an offer to that most qualified candidate. So then that takes us to step 4 of the total overall process of making the offer to the most qualified candidate. You should use a template offer letter. Hopefully by now you have received that email. I believe it got sent out once we started. So let us know if you haven't received our template offer, but either use ours or a template that you have. This again helps maintain consistency and makes sure that all of the required communications are in there, as well as that there's not any sort of stray stuff that shouldn't be in the offer letter. So things to include would be, the initial terms of employment, the very basics of title, pay, benefits. All of that is very important to get out there and be clear about, as well as make sure that you do have an at-will employment statement in the template offer letter so that they are aware that it is at will and that you can terminate them at any time for any lawful reason. And then be sure to include the conditions for employment, so that if you're requiring a background check or drug and alcohol test or anything along those lines, you have to be explicit that those are required, to again remind them, as well as requiring that those restrictive covenants be returned before the start of employment, because in order to be valid, the applicant needs to be given consideration in exchange for, say, a non-compete. And the only way the job is consideration is if they sign these non-competes before starting employment. Otherwise, if you require a non-compete after the start of employment, you need to offer them something else of value in exchange for that binding covenant. So, for example, a bonus or something along those lines. And then lastly, be sure to include any sort of due dates for acceptance and for returning those non-competes if required. So the offer letter should also include instructions if there are any of those pre-hiring conditions, including FCRA disclosures and consents. If a drug and alcohol test is required, be sure to include a copy of the testing policy and to get a written consent beforehand. These are two, as Ingrid mentioned, these are two very technical statutes where the technicalities really matter, and there is severe liability even if you err on the technical aspects of these laws. And as I mentioned, be sure with the restrictive covenants that you get them before the date of start date. After you make the offer, if you are requiring any of these background tests or drug tests, then complete the additional testing after making the offer and getting the necessary consent. If you do require a background check, make sure that you follow the FCRA's requirements in reviewing the results. Make sure it's a case-by-case review, including a discussion with the candidate if there are results that you find troubling, and consider things such as whether the crime happened a long time ago, whether it impacts their ability to do the job, or whether there are other mitigating factors related to the criminal history that may show up on the background check. Finally, if you do decide to revoke the offer based on the background check, again, make sure that you're following the FCRA in doing so. You do have to send a pre-adverse action notice to notify the candidate that that's what you're doing and give them the chance to explain. And then you do also have to send an adverse action notice once you've decided to do the adverse action and after you've submitted the pre-adverse action notice. So that was a background check. Same with a drug and alcohol test. There's very explicit requirements as to when you can do a background check, the documentation that has to be in place, or I'm sorry, drug and alcohol test, the documentation that has to be in place for doing a drug and alcohol test. There's also an array of obligations on the back end, including notification requirements related to the results of the test, retesting obligations if the person tests positive, as well as strict confidentiality obligations of who can be informed of the results and things of that nature. Along those same lines, under the drug and alcohol test, you cannot revoke an offer unless there is a positive test that is confirmed on retest. So it goes with those same requirements of requirements and notification, and it all ties back to the theme of communication. So if you have issues related to either of the background check or the drug and alcohol test, be sure to reach out to counsel, as there are lots of these technical requirements, and we can help you through any sticky situations. So then finally, after conducting all those tests, deciding whether to go forward with the candidate that you originally selected, if the candidate passes, then you confirm that the offer is final and make sure that you have all of those things that you requested in the initial offer letter, including any required restrictive covenants. And at that point, then you're free to notify the other applicants who you interviewed that you did not select them, and be prepared for any questions back to you as to why they were not selected. So be very intentional and thoughtful as to why you selected the person in the first place, and similarly why others were not ultimately selected. If, on the other hand, you decide to revoke the conditional offer, then you need to decide how you're going to move forward from there. Obviously, you need to follow all the notification requirements under the various laws if you did any sort of background test or drug testing. And you need to decide whether there was another candidate who was a close second and you just want to go ahead and select that person, or whether you want to restart the entire process. And if you decide to restart the entire process, then obviously just continue, retrace those steps that we outlined previously. So then the last step of the new hire process will be to do new hire onboarding. So all of that time and effort was rewarded, and you found a great candidate and you've hired them and they've accepted the offer. Now it's time to set them up for success in your organization. And so much like the process up to this point, it's good to have a standardized approach to make sure that you are including everything that you should be, getting all the information that you need, as well as, excluding any extraneous things that shouldn't be included in the process. So we have given you a sample checklist that helps you track all of the documents and things that you should be obtaining through the new hire process, as well as some other good best practices to follow in orienting the new individual. And as a part of this, you should determine who is the best person to be overseeing this process. It's good to centralize this with one person so that it stays consistent and this person is familiar with the process and with all of the various factors involved in them. So along those same lines, you need to collect an I-9. The Section 1 needs to be completed on or before the first day of work, and Section 2 within 3 days of work. For retention, you need to keep them for 3 years after the date of hire or 1 year after separation, whichever is later. Other documents you'll need to collect include a W-4, as well as additional documentation outlined in the new hire checklist. So you also, as a part of the new hire onboarding, should be reviewing substantive policies, including the employee handbook, and making sure that the employee really does understand the policies in the employee handbook and get their signed acknowledgement so that you have record that you reviewed it, that they've read it, they understand it, and that they will be held accountable for the policies in there. You would not be surprised at the number of times this comes up in litigation, that later an individual who broke the policy, we use this as evidence that yes, they were well aware that this was a requirement of the job. They signed, and we use this signed acknowledgement as proof of that. So it really is important that you go over this handbook and get that signed acknowledgement from the employee. And then the other documentation too, the emergency contact, the direct deposit, employee benefits, enrollment, all of that stuff is all part of the new hire onboarding process that should be a part of your standard process that you get from all of the new employees. And then just introducing the employee to the building and to their coworkers, to their managers, going over everything from how the printer works to where the cafeteria is. All of this will help get the employee familiar with the building and feel comfortable and set them up for success at their job, as well as going over job assignments, training plans, expectations, all to lay the groundwork of what's expected of them to hopefully prevent any sort of issues with things like attendance or performance, but also to provide further support if it does become an issue. That look, you set the clear expectations early on and they knew them and they failed to abide by them. So all of this is, again, helpful both in prevention as well as enforcement later if it does become a problem. Be sure as a part of all of this introduction and training that you're completing any sort of new hire training as well of important topics such as anti-discrimination, safety, things along those lines will help both prevent claims and defend against them later on. And then finally, also remember to report any new hires to the state. Under state law, you're required to do that within 20 days of hire. You should also create and maintain a personnel file for everyone. There's a Minnesota state law that dictates what exactly should be in a personnel file and what needs to be segregated into separate confidentiality files. So be sure to create that documentation and maintain them as the employee continues on with their job. And then you are all set to employ this person, and you are off to the races. Hopefully the candidate is successful, both for their own terms and for the business. And then the last step would be to try to retain them. And that is an entirely different topic for another time because it could take a full another hour. So with that, we will turn it over to questions.
Great. Yeah, I have a few here that I can get us started with. So the first question I have is, do I have to notify applicants that they will not be interviewed? So you've decided who you're going to interview and who you're not going to interview, and is there any obligation to notify applicants that they have not been selected for an interview? Legally speaking, there is no requirement to notify applicants that they have not been selected for an interview. So legally, you can just go silent on those applicants. Practically speaking, I think most employers consider it a best practice, particularly if the applicant pool is fairly small, to reach out to applicants to let them know that they haven't been selected for an interview. And more than anything, just as a communication tool so that they know their status and you are not barraged with phone calls or emails asking about their status. Now, I know that there are some employers that are so large and have so many applicants for so many open positions that that's just not practical. So I do think it's kind of a case-by-case decision what your company's approach is going to be with regard to communicating with applicants that have not been selected for an interview. I have, as we're waiting for a couple more questions to come in, a couple other things I thought of during our comments, some common questions I get. So Ashley mentioned how important it is with regard to your employee policies, your employee handbook and the like, to collect and keep on file a signed acknowledgement of receipt. And I absolutely agree with her. I oftentimes have clients ask me if it actually has to be a hard copy signature on paper or whether there is an electronic way of collecting and maintaining acknowledgement of receipt. And the answer is yes. You don't have to get an actual signature with pen and paper and print that out and keep it in a hard copy file. You certainly can, and that's what we've seen most common historically, and that continues to be very effective. But if you are trying to go more paperless at your organization and you want to collect and then be able to maintain acknowledgement of receipt electronically, that is just fine. The keys to doing that, though, are that the individual signing for receipt, for lack of a better term, actually has to do something affirmative. They have to check a box or they have to sign something electronically. They have to affirmatively do something. And then, equally important, is that you be able to keep a record of that. So if months or years down the road, you want to be able to prove that that employee received that policy or participated in that training, that you are able to readily access that and produce that. Another thing that I wanted to talk about just a little bit more was background checks. So as we mentioned in Minnesota, you cannot inquire about background checks on an employment application. In Minnesota, the first time that you can require of a criminal history for your applicants is once they've either been selected for an interview or they've been offered employment. So those are the first junctures that you can say to somebody, hey, do you have a criminal history? And if so, what is it? Then along those same lines, Ashley mentioned that if you do a background check or if somebody voluntarily offers that they do in fact have a criminal history, and something pops up that is causing you to wonder whether you want to employ the individual, the EEOC, our Federal Anti-Discrimination Enforcement Agency, does require that you do a case-by-case analysis to consider, as Ashley said, both how long ago this criminal history happened and whether it's job-related. And just as a general guideline, anything that's older than 7 years is considered fairly stale. It doesn't mean you can't consider something that's more than 7 years old, but if you're going to consider something that's more than 7 years old, it better be pretty significant. And then the whole job relatedness issue too is important. If you're going to decline employment based on a criminal history, we should be able to show that the nature of the criminal history itself has some bearing or some relatedness to the job that you're hiring for. So some really obvious examples would be an embezzlement charge for somebody who's going to handle money or finances for your company, or child molestation charge for somebody who's going to work closely with children. I mean, those are some really obvious examples. In my experience, it's not typically as clear as that. There's a lot of gray when it comes to this analysis, and oftentimes employers are in a tough position of having to make a difficult decision. And if you ever want help with those decisions, we're of course happy to help. Did you have a question come in?
Yeah, so I have a couple here. The first one asks or indicates that a number of states are prohibiting inquiries around salary history. Is Minnesota considering this at this time? And I am unaware of any state law related to salary history or any consideration at this time. So I would say, given the state of this issue, I would call it a best practice not to inquire about salary history, particularly given all of the policy considerations underlying this movement, that there's claims that using salary history is a form of sex discrimination because of the disparity in pay typically associated with various forms of salary, and that just causes a snowball effect if you are using someone's prior salary history to base their current salary on. I think it's a better practice to, before you even hire someone, have an idea of what you're willing to pay a salary for and base that salary solely based upon the person's qualifications and your desire to hire that person without effect to what they were previously paid.
And I would just add to that, it's just fine to ask a candidate what they're seeking from a compensation standpoint. So it's just fine to say, what are your expectations with regard to compensation? But I agree with Ashley, given the number of states that have adopted these laws prohibiting employers from asking about prior compensation levels with prior employers, I think it's a best practice to exclude that from the line of questioning. Okay, I have a question here, and then we should wrap up in the next minute or so. So the question is, if a company previously let someone go from their employment, terminated them, is there a rule for that individual applying for another job back with the same company? There is no rule. So if a company has terminated an employee, they can decide whether that individual is eligible for employment in the future or not. And it really would be, I think, case by case, depending on the reason for termination, and whether this company is willing to give this individual another chance or not. I will caution employers against having blanket no rehire provisions. So when a company has just decided to say that one or more individuals are simply never eligible for rehire with their company, some of our enforcement agencies have taken issue with that because it does not leave open the possibility of somebody changing their ways or becoming a better employee down the road. So I'm a little bit hesitant on these blanket no rehire records that I sometimes see companies use. But the short answer to the question is no, there's no magic rule or law about when that person can be reconsidered for employment or if they have a certain waiting period. Okay, we had a couple more questions come in. We are going to end our time together now, and we will reach out to the few individuals who we did not have time to answer your question. So thank you so much for being with us today on behalf of both myself and Ashley. We hope the information was informative and there was at least a couple nuggets for you to take back to your team. And if you have any questions, whether it's today or in the coming weeks or months, please feel free to reach out to us. We're very happy to help. Thank you so much and have a great afternoon. Take care.